The first time I saw my own psychiatric history attached to a petition about my husband, I was sitting beneath a crooked painting of 3 sailboats in a hospital conference room. Nathan had been unconscious for 3 days. His mother had been talking for 6 minutes. I stopped listening after the words unstable under stress. The petition sat between us in a blue court folder. Diane had brought her attorney. I had brought a black fountain pen Nathan gave me after my last army assignment because I had been using it to write questions for his doctors. Medication changes, neurology consult, whether the swelling had improved. Things a wife should have been thinking about. Not whether her mother-in-law had just asked a court to decide she was too psychologically unreliable to help make decisions for her husband. Diane folded her hands on the table. This is temporary, Ray. I looked at the first page again. Petition for appointment of guardian and conservator. The respondent was Nathan Mercer. The petitioner was Diane Mercer. My name appeared 11 times. Temporary, I said. Diane nodded as if I had agreed with her. Nathan needs stability. The company needs stability. Everyone does. I did not answer. Instead, I turned to the exhibit attached behind the petition. It looked clinical enough to fool someone who wanted to be fooled. There was the name of my psychologist, Dr. Miriam Roth. There was a treatment date I recognized. There was a diagnosis I had never hidden from Nathan. Post-traumatic stress disorder, that part was true. Then I reached the sentence that was not. Patient has demonstrated dissociative episodes under acute stress and may experience impaired judgment during emotionally destabilizing events. I read it twice, then a third time. I had never seen that sentence before. Diane watched my face. That was her first mistake. People who expect an explosion often reveal more when they get silence instead. You understand why we had to include it, she said. I kept reading. The document referred to concerns regarding decision-making during family emergencies. It suggested I should not be relied upon as the sole point of contact during periods of crisis. I looked up. Where did you get this? Diane's expression barely changed. Ray, this is not the time to make everything adversarial. That wasn't my question. Her attorney shifted in his chair. Diane answered anyway. Nathan shared things with me over the years. That was not an answer either. I closed the folder. Outside the conference room, a monitor alarm sounded twice and stopped. Somewhere down the hall, a cart rattled across a metal threshold. Diane glanced at the wall behind me. The sailboat painting was crooked. I reached up and straightened it. That was the kind of thing I did when I needed my hands to stay busy. Diane knew that. She also knew enough about my history to call it something else. By the time we stepped into the hallway, her attorney had moved ahead to take a phone call. Diane stayed beside me. You need rest. I need accurate information. You've been sleeping in a chair for 3 nights. So have half the people on this floor. This is exactly what I mean. I stopped walking. She lowered her voice. You spent your career evaluating rules. Nathan is not a case file. He's my son. There were a dozen answers I could have given her. I chose none. Then she added, there are people depending on him who cannot afford for this family to fall apart. That sentence stayed with me, not because of what it said. Because of what it did not. Nathan had been in intensive care for 3 days, and Diane had just spoken about people depending on him as if she meant more than family. I called Elena Park. I had known Elena socially for less than a year. She practiced elder law in Northern Virginia and had once explained why families waited too long to put basic documents in place because nobody wanted to imagine a crisis. Nathan and I had been 2 of those people. That fact now felt expensive. Elena answered on the second ring. Rachel, I need a lawyer. There was a pause. Are you safe? Yes. Is Nathan? I don't know yet. That was enough to change her voice. I gave her the shortest version. Nathan unconscious. His mother filed a petition, my mental health history attached as an exhibit. Elena did not react to the diagnosis. She asked, do you have the exact filed copy? Yes, paper or electronic. Paper, I can get the docket copy. Good. Do not mark the exhibit itself. Do not run the electronic file through an app that changes it. Preserve the original if you can. I glanced through the glass wall. Diane was talking to her attorney. What are you thinking? I'm thinking guardianship is supposed to solve incapacity, not solve a family disagreement. She paused. Now tell me exactly what the exhibit says. I read her the sentence about dissociative episodes. Then the line about impaired judgment. Then I told her the date at the top. Elena interrupted me. Say that date again. I did. A quiet part of my mind clicked into place. Dr. Roth had not seen me that week. Nathan and I had been in Richmond helping his cousin move. I still had a photograph of Nathan carrying a lamp downstairs and pretending he had not strained his back. I looked back at the page. The date was wrong, not dramatically wrong. Just wrong enough. Rachel, I'm here. Call Dr. Roth's office. Don't ask them to discuss treatment details over the phone. Ask what process they require for you to obtain your own records and verify documents attributed to the practice. All right, and get me the filed electronic exhibit. I will. Not a screenshot, I know. For more than 20 years, I had watched people destroy useful evidence by handling it carelessly because they were in a hurry to prove what it meant. I had no intention of doing that now. I went back into the conference room alone. The court folder was still on the table. Someone had bumped the chair near the wall. The sailboat painting was crooked again. This time, I left it that way. I uncapped Nathan's black fountain pen and opened my notebook. I wrote 3 questions. Who created the exhibit? When was it created? What decision was Diane trying to reach before Nathan could speak for himself? Then I underlined one word, source. By the next morning, source had become a person. His name was James Holloway, and the circuit court had appointed him to serve as Nathan's guardian ad litem. He met me in a consultation room 2 floors below intensive care. He carried a legal pad with one corner folded back. I represent Nathan's interests for this proceeding, he said. Not his mother's, I understand. Good. That saves time. He asked about Nathan's condition, our marriage, our finances, and what legal documents we already had in place. That was where I had to give him an answer I hated. We talked about an advance directive, I said. We never completed one. He wrote it down, no judgment, no sympathy either. What did you and Nathan have in place before the accident? Joint household accounts, separate retirement accounts. Beneficiary designations, no durable financial power of attorney. And health care? Nothing formal beyond routine hospital paperwork. He stopped writing. Did anyone discuss a less restrictive arrangement before this petition was filed? No. Did Diane ask whether you would agree to a neutral temporary arrangement? No. He turned the page. What is Mercer Mobility Supply? The question caught me off guard. Nathan's family company. What does it do? Rehabilitation equipment, mobility systems. Institutional contracts. Is Nathan involved in daily management? Not anymore. Does he own part of it? Yes. How much? I don't know the exact percentage. James noticed the hesitation. Should you know? I know enough about our household. Nathan kept the family company separate, by his choice or yours. Both. He wrote that down too. Then he asked a question I would remember later. What did anyone try before asking the court to take control? They didn't. James closed the legal pad. That was all he gave me. He interviewed Diane separately. I was not in the room, but Elena called me afterward. She's leaning hard on 2 things, she said. My PTSD. Yes, and the company. I stood beside a vending machine that had hummed for 3 days without stopping. What about it? She says Nathan's incapacity is creating urgent business problems. Payroll, vendor obligations, decisions that cannot wait. That wasn't the reason she gave me. Families often give each other the emotional version and courts the practical one. I looked through the glass doors. Diane was outside speaking into her phone. She said there were people depending on him. How many? I don't know. Don't investigate the company yourself, Elena said. Let the court process do what it's supposed to do. You say that as if you think I might get curious. Retired lawyers are still lawyers. That afternoon, Nathan was awake for less than 3 minutes. Not truly awake in the way families hope when they hear someone opened his eyes. He followed the neurologist's finger once. He squeezed with his left hand. His right arm barely moved, then he drifted back under. I sat beside him after the doctors left and turned on the little battery radio he kept in his garage at home. Nathan hated silence almost as much as he hated hospital television. A baseball game came through beneath a layer of static. He would have complained about the announcer. I let it play anyway. For 20 minutes I did nothing useful, no records. No court documents, no questions. I only sat beside my husband and listened to a game neither of us cared about. Then my phone buzzed. Diane, hearing moved up, Friday morning. No hello, no explanation, just a deadline. By Thursday night, Elena had the court file spread across a conference table. She placed red tabs on 3 documents. Each tab carried 1 word. Sans quoi I looked at the psychiatric exhibit again. You still haven't heard from Dr. Roth? Her office confirmed your authorization. They're pulling the file. Elena slid another document toward me. "This is Holloway's preliminary report," I read it. "Nathan's current condition supported temporary assistance." No surprise, then I reached the section discussing me. Rachel Callahan, spouse of the respondent, retired United States Army officer. 22 years of service, Judge Advocate General's Corps. Final grade Lieutenant Colonel. I stopped. "Why is this here?" "Because Diane put your fitness at issue. Holloway checked who you are." "I didn't ask him to. That's probably why it matters." The report did not praise me. It did not call me distinguished. It simply stated what Holloway had verified: my service. My legal background, my retirement, my treatment history remained a separate question. That distinction mattered. Do we need any of this tomorrow? Only if they keep pretending you cannot understand the process. I don't want my career used as character evidence. Neither do I, Elena tapped the report. Your rank doesn't prove you're emotionally fit. Your diagnosis doesn't prove you're emotionally unfit. Those are different questions. The courtroom Friday morning felt smaller than the ones I remembered from military practice, partly because Nathan was not there to see it. Diane sat with her attorney 3 seats away. She wore charcoal gray and pearls. Serious clothes, her attorney began by talking about urgency. Nathan could not presently manage his affairs. Important financial decisions were approaching. His mother had decades of familiarity with the family business. His wife, counsel said carefully, had a documented psychiatric condition that raised legitimate questions under acute stress. Elena did not object to the diagnosis, she objected to the conclusion. The judge asked James Holloway for his preliminary position. James stood. He spoke about Nathan first. That pleased me. He spoke about medical evidence, current limitations, and the need to preserve Nathan's interests without taking more authority than necessary. Then he reached me. "Mrs. Callahan's history includes treatment for post-traumatic stress disorder," he said. "I found no independent evidence at this stage that the diagnosis, standing alone, renders her incapable of participating appropriately in her husband's care or this proceeding." Diane's attorney looked down. James continued, "For context, Mrs. Callahan retired from the United States Army as a lieutenant colonel in the Judge Advocate General's Corps after 22 years of service, including senior administrative law assignments." Diane turned toward me, not quickly. She looked slowly, as if the sentence required her to rearrange something she had already decided was true. Her attorney stopped calling me Mrs. Callahan. He began calling me Colonel Callahan. I disliked that more. The judge asked about the psychiatric exhibit. Elena said the source had not yet been authenticated. Diane's attorney said authentication was underway and that the underlying diagnosis was disputed. "Diagnosis is not the issue," Elena said. "The attributed conclusions are." The judge agreed. Then she made the ruling I had been hoping to avoid. Not Diane, not me. A neutral temporary conservator would be appointed for Nathan's financial affairs while the evidentiary questions were resolved. The court left the existing health care process undisturbed while Nathan's condition evolved. It was restrained, temporary, reasonable, and it felt like losing. Diane had not been given control, but neither had I. Outside the courtroom, I stood with Elena near a window overlooking the parking lot. Diane and her attorney were behind us. I heard paper move. Then Diane asked very quietly, "Can the vote still happen?" Elena looked at me. I did not turn around. For the first time, the psychiatric report felt less like the center of the case. It felt like a door someone had built in front of something else. The vote turned out to be about more than a meeting. The temporary conservator was a woman named Claire Donnelly. She immediately requested a list of Nathan's major assets, ownership interests, pending contracts, and any transaction requiring action before the next hearing. Mercer Mobility was on the list, so was a proposed sale. "What exactly is being sold?" I asked Elena. "We don't know yet." "And the vote? We know enough to stop guessing." Claire would request the company records. Diane would almost certainly object. That answer bothered me all the way back to the hospital. Not because it was vague, because it was careful. Careful answers usually meant there were still too many possible truths. Dr. Roth's office finally returned my call that afternoon. Her staff gave me instructions for obtaining my treatment records and sent the same material to Elena with my authorization. I opened the records on my tablet in the family waiting area. The first thing I noticed was how ordinary they looked. Real records often do: dates, progress notes, medication history from years earlier. Treatment goals: A short discharge summary from the period when my appointments became less frequent. I found the date shown on Diane's exhibit. There was no appointment. No evaluation, no report, nothing. Dr. Miriam Roth called me herself later that afternoon. I had not spoken to her in almost 2 years. Her voice sounded exactly the same. Low, measured, almost impossible to rush. Rachel, I have the document your attorney sent. I moved into an empty consultation room. Did you write it? No, she answered so quickly that something in my chest loosened. Then she kept going. Some underlying information appears to have come from my records. Your diagnosis is accurate. A treatment date from an older note is accurate. The practice address is ours, but the conclusions? No. Did you ever describe me as having dissociative episodes? No. Did you ever conclude I should not make decisions during family emergencies? No. I looked at the hand-washing poster peeling from the wall in front of me. Could someone misunderstand something you wrote? People can misunderstand almost anything, she paused. But this is not a misunderstanding of my language. That changed the temperature of the room. What is it? I can defend my diagnosis, she said. I cannot defend a sentence I never wrote. She would provide a declaration through proper channels. She would authenticate the records the practice actually maintained. She would not speculate about who created the other document. Neither would I, not yet. The next morning Claire called. She was already inside Nathan's financial life in a way I was not. That stung even though I understood why. I requested corporate records from Mercer Mobility, she said. Counsel objected to several categories. On what basis? Confidentiality, trade information, scope. Do you think the objections are legitimate? Some may be. I appreciated that answer. What do you need from me? For now? Nothing, she paused. Mrs. Callahan, my job is not to help you win a family dispute. I know, my job is to preserve Nathan's interests while he cannot speak for himself. That's what I want, I hope so. The line went quiet. One thing I can tell you, there is a proposed transaction involving a major operating division. It requires shareholder approval. How soon? I'm waiting on the complete packet. Does Nathan's vote matter? Another pause. Very much. That was the first time anyone outside the family said it plainly. The psychiatric exhibit had not appeared beside a vague concern about stress. It had appeared beside a deadline. Elena requested the electronic version of the exhibit as it had originally been submitted. Not a printout, not a scan of a printout, the actual file. 2 days later she called me. I need you here. A man I had never met was sitting at the conference table with a laptop open when I arrived. Elena introduced him as Noor Patel, a digital forensic examiner. Noor did not shake my hand until after he finished typing. Then he apologized. I don't like touching anything once I start documenting a process. I understood him immediately. Elena slid the exhibit toward me. Tell her only what you can support, Noor nodded. The file represented to the court as an older clinical document was not created on the date printed inside it. My shoulders went still. When was it created? After your husband's accident. I did not ask him to repeat it. He turned the laptop so I could see a simple timeline. The words are one layer, he said. The file's history is another. The document had been generated from a word processing file. It had gone through several revisions. Then it had been exported as a portable document after Nathan was already in intensive care. Can you tell who created it? Not responsibly yet. That answer mattered more than certainty would have. Can you tell whether it came directly from Dr. Roth's office? Based on what I have now, it doesn't behave like the records her office produced for comparison. Elena looked at me. Rachel, what do you want to do? Until that moment, every step I had taken had been defensive. Verify my records, challenge the exhibit, keep Diane from using a diagnosis as a substitute for proof. That was no longer enough. Someone had created a false document after Nathan lost the ability to object. And they had created it while a business decision waited for his vote. I uncapped Nathan's fountain pen. The black ink had bled slightly into the paper where I had pressed too hard beside the word source. I drew a line beneath it, then I wrote another word. Purpose, preserve every version you can lawfully obtain, I said. Elena nodded. And the company? Find out what decision she's racing toward. That was the moment I stopped trying to survive Diane's story about me. I started examining hers. Claire's next packet arrived the following afternoon. Mercer Mobility Supply was not collapsing. That would have been simpler. It was squeezed. The company had expanded warehouse capacity 18 months earlier using short-term financing. A major hospital contract had been delayed, 2 vendors had tightened payment terms. And 39 days from the date of the petition, a balloon payment of a little over $400,000 would come due. The proposed solution was to sell the company's most profitable operating division to a larger regional distributor. Cash would arrive quickly, debt pressure would drop. Payroll would be protected, at least in the short term. The problem was Nathan. He owned 34% of the voting interest. The proposed sale required more support than Diane, and the remaining aligned shareholders could produce without him. I read the figures twice: 82 employees, 39 days. 1 vote. For the first time, Diane's behavior formed a shape I could recognize. Not a good one, but a human one. Panic rarely introduced itself as panic. It called itself urgency, responsibility, the only practical choice. That evening I sat beside Nathan with the radio between us. The batteries had died. I replaced them and turned the volume low. Static. Nathan's eyes opened. "Hey." His gaze moved slowly toward me. Bad announcer. His mouth shifted. It might have been the beginning of a smile. I took his hand. For 1 second, his fingers tightened around mine. There were questions I wanted to ask. Did you know about the sale? What did you tell your mother? Why did she have Dr. Roth's information? I asked none. A man who could barely stay awake was not evidence. He was my husband. 39 days was enough time to make a frightened person reckless. It was also enough time to prove what they had done. Claire found Nathan's yellow legal pad before anyone found another email. It was in the bottom drawer of his desk at Mercer Mobility, beneath 2 vendor folders and a package of peppermint gum he kept pretending he had quit buying. Nathan divided difficult decisions into 2 columns. Keep cost, he had done it for years, cars, vacations. Whether we should replace the roof before it actually leaked. The page Claire sent Elena had the proposed division sale written across the top. Under keep, Nathan listed quick cash, lender relief, and payroll protection. Under cost, the list was longer: loss of recurring revenue. Loss of control, buyer could cut warehouse staff after closing. No guaranteed jobs remain after 6 months. At the bottom, in block letters, he had written, "No until workforce plan." I stared at it longer than I needed to. Nathan had not rejected the sale because he was sentimental. He had rejected it because he thought Diane's solution moved risk from the company onto the employees she claimed she was trying to save. I remembered their last argument before the accident. It happened in our kitchen. Diane stood beside the island with her coat still on. Nathan was making coffee even though it was nearly 9 at night. There are 82 paychecks attached to this. Nathan did not raise his voice. Then bring me a plan that doesn't sell the engine to pay for the tires. Diane called that dramatic. Nathan called it arithmetic. At the time, I thought it was another family business disagreement I was grateful not to understand. Now it sat inside a court proceeding. Claire's discovery changed something immediately. Diane could no longer honestly claim she was merely trying to carry out Nathan's wishes. It did not prove she created the psychiatric exhibit. For that, we still needed the file. Noor called the next morning. He had completed a more detailed examination. Elena put him on speaker. "I can support 4 points," he said. I appreciated that he started with the limit. The document submitted to the court was created after Mr. Mercer's accident. It originated as a word processing document, not as the clinical record format Dr. Roth's practice provided for comparison. It was revised multiple times, and the final file was exported from a user profile associated with the name Diane Mercer. Nobody spoke for a moment. I asked, "Associated how strongly?" "Strong enough for me to report the metadata accurately. Not strong enough for me to testify that I watched her type the document." "Good," Elena looked at me. "Good, I don't want more certainty than we have." Noor gave a small laugh. "That makes 2 of us." He found something else. The earliest version he could reconstruct contained only fragments of the language eventually submitted to court. Later revisions added the statements about impaired judgment. Then family emergencies, then the recommendation that I not be relied upon during crisis. The document had not been copied whole from somewhere. It had been built, layer by layer. A mistake is usually messy. This had been edited toward a purpose. By afternoon, Diane's attorney changed the story. He no longer defended the document as an original report from Dr. Roth. Diane, he said, had received material from someone close to Nathan. She believed the summary accurately reflected concerns known within the family. She had provided it to counsel in good faith during an emergency. Elena read the letter. That's better lawyering. For her? For her attorney, he stopped defending the weakest fact. Which means they'll argue misunderstanding instead of fabrication. If Diane thought it was a summary, why did it have Dr. Roth's name on it? Exactly, and why make it look clinical? And who gave her enough information to make it believable? Elena did not answer. She had already asked the same question. The answer came from Nathan's old email account, not through some dramatic forensic recovery. Claire found it while reviewing business communications. 3 years before the accident, Nathan had forwarded his mother a short note from Dr. Roth's office. I remembered the trip. Diane had been coordinating hotel rooms for a family reunion. I had an appointment that morning. Nathan apparently sent her the note to explain why we would arrive late. It contained almost nothing: my name, Dr. Roth's name. The practice address, a treatment date, a brief line confirming I was receiving care. That was all. Nathan's message above the attachment read, "Mom, this is all you need. Please don't pass it around." I felt colder reading that than I had reading the fake report. Diane had not broken into anything. Nathan had opened the door. Only a few inches, years earlier, without understanding what could someday be carried through it. Elena watched me. "You all right?" No. It was the first time I had given her that answer. Nathan had not betrayed me the way Diane had, but privacy does not disappear because the person crossing the line loves you. "What does this change?" I asked. "It explains access." "Not intent, no." Then we keep going. 2 days later, Elena received the filing email chain from Diane's attorney under the court's production order. The altered psychiatric file had come from Diane's personal account. It was attached to a message sent the morning after Nathan's second night in intensive care. Her note was short. "This supports my concern about Rachel handling emergency decisions. Please include whatever is useful." There was still room for Diane to argue she believed the document was legitimate. Then Claire found the other email, same week, different recipient. Diane had written Mercer Mobility's outside financial advisor. "Nathan is still unable to participate. Without his vote, the transaction is dead unless the court gives someone authority to act for him." I read the two messages side by side, not because either proved everything. Because chronology can say what people refuse to. Nathan opposed the sale. Nathan became incapacitated. A psychiatric document attacking my fitness was created after the accident. Diane sent it to her lawyer. Then she asked how quickly someone could gain authority over Nathan's vote. For days, I had been trying to understand whether Diane had lied because she feared me. Now the question looked different. Maybe she needed me disqualified because she already knew exactly what I would do. I would ask what Nathan wanted, and Nathan had already answered. "The hearing is Monday," Elena said. I looked at the black fountain pen beside my notebook. For most of my adult life, I had believed restraint meant waiting until every uncertainty was gone. That was not restraint. Sometimes it was fear dressed in professional clothing. We had enough now to ask the court the right question. Not whether I had PTSD, not whether Diane loved her son. Not even whether the company was in trouble. The question was whether someone had manufactured a reason to remove one voice because that voice stood between them and a deadline. On Monday, Elena set one black binder on counsel table. The metal rings struck the wood with a small click. In the silence that followed, I could hear the ventilation above the judge's bench. There were 5 tabs: Dr. Roth's authenticated records, Noor's file history report, Nathan's handwritten objection to the sale, Diane's 2 emails, and behind the last tab a single-page timeline. Accident, creation, filing, vote, no argument was written beneath it. That was the point. For weeks, other people had been describing who I was. The binder did not describe anyone, it only recorded what happened. Dr. Roth testified first. Elena began with the part nobody disputed. "Did you treat Rachel Callahan?" "Yes." "Was she diagnosed with post-traumatic stress disorder?" "Yes." "Does that diagnosis, by itself, mean a person cannot make legal, medical, or financial decisions?" "No." "Did you write the document filed as Petitioner's Exhibit 4? "No." "Did you ever state that Mrs. Callahan experiences dissociative episodes under acute stress?" "No." "Did you recommend that she not serve as a sole point of contact during a family emergency?" No. Diane's attorney stood for cross-examination. He was careful now. "Doctor, your treatment records acknowledge hypervigilance." "Yes." "Sleep disruption, at times heightened stress responses." Yes, so the document contained concepts associated with her actual treatment. Some concepts. Then it is possible someone summarized your concerns. Miriam's expression did not change. It is possible someone summarized my records. She paused. It is not possible that they accurately summarized a conclusion I never reached. That ended more than the question. It ended Diane's ability to hide invented conclusions inside a real diagnosis. Noor testified next. He did not describe hacking. There had been none. He explained file history. The exhibit was represented as an older clinical document. Its electronic history showed creation after Nathan's accident. It originated from a word processing file. It was revised several times. It was exported from a user profile associated with Diane Mercer. Elena displayed 3 dates: Nathan's accident, the document's creation. The filing, nothing more. Noor explained that later revisions added the strongest statements about my judgment. Diane's attorney objected when Elena used the word fabricated. The judge sustained him. Elena changed it immediately. Modified. Noor nodded. Yes, we did not need theatrical language. The chronology was already doing enough work. On cross-examination, Diane's attorney asked whether metadata could be wrong. Yes, Noor said. That answer seemed to surprise him. You agree that user profile information does not prove who physically typed every word. I do, so you cannot testify that Diane Mercer personally wrote these sentences. No. Diane looked toward the judge. No eyewitness. No confession, no video of her at a keyboard. Noor continued. What I can testify to is that the file submitted to this court was created after Mr. Mercer's accident, was revised through a profile associated with Mrs. Mercer and did not originate as the clinical record it was represented to resemble. James Holloway was the third witness. His testimony was less dramatic. That made it harder to dismiss. He had interviewed me. Diane, Nathan's physicians, Claire. He had reviewed the actual treatment records, the altered exhibit, and the information regarding Mercer mobility. Elena asked him the same question he had asked me during our first meeting. What less restrictive alternative was attempted before the petition sought control over Mr. Mercer's affairs? None that I could identify. Was Mrs. Callahan asked to participate in a neutral temporary arrangement before filing? No. Was mediation attempted? No. Was an independent temporary fiduciary proposed? Not before the petition. What was the stated urgency? Initially, Mr. Mercer's incapacity and concern regarding Mrs. Callahan's stability. And what did your investigation later reveal? That a substantial corporate transaction also required action within a limited period. Diane's attorney stood. Objection. That does not establish improper motive. Sustained. James nodded. He had not claimed it did. Nobody needed to force the conclusion before the evidence arrived. Claire testified last. She explained Nathan's ownership interest. 34%, the proposed division sale, the approaching balloon payment. The voting threshold the company could not reach without Nathan's participation or someone legally authorized to act for him. Elena showed Nathan's yellow legal pad. The judge read the final line silently. No until workforce plan. Diane's attorney argued that handwritten notes were not binding corporate instructions. He was right, Elena agreed. They are not offered as binding instructions. They are offered to show that before losing capacity, Mr. Mercer had not approved the transaction, his mother later described as urgent and necessary. Then came the 2 emails. The first was Diane's message attaching the psychiatric exhibit. The second was the message stating the transaction would die without Nathan's vote, unless the court gave someone authority to act for him. Elena did not ask me to testify about either. She did not need to. By then, the timeline was visible without narration. The judge asked Diane whether she wished to testify. She did. Diane took the oath and sat straight in the witness chair. She admitted sending the document. She denied believing it was false. She said she understood it to be a summary of concerns already known within the family. She admitted knowing Nathan had opposed the sale. Then she made the argument I think she had believed from the beginning. 82 people work for that company. Her voice shook for the first time. They have mortgages, children, health insurance. Nathan was unconscious, the payment was coming due, and Rachel would have blocked anything involving the company because she never trusted us. Elena waited, then asked, "Did you ask her?" Diane looked at her. "Excuse me, did you ask Rachel whether she would oppose a neutral review of the transaction?" "No." "Did you ask for mediation?" "There wasn't time." Did you ask the court to appoint a neutral conservator before filing material about Rachel's psychiatric history? No. Did Dr. Roth tell you Rachel was incapable? No. Did Rachel? No. Did Nathan? Silence. Elena stopped. There was no need for another question. Diane had reached the center of her own argument. She had not known I would block the deal. She had decided I would. Then she treated that prediction as permission to remove me. The judge took a recess. I sat beside Elena. Across the aisle, Diane sat alone while her attorney spoke quietly to someone near the door. She did not look defeated. She looked tired. That was harder to hate. When the judge returned, her ruling was narrower than anger would have been. And stronger. She found no sufficient basis to treat my PTSD diagnosis as evidence of incapacity or unsuitability. She found the psychiatric exhibit unreliable and directed that it be preserved as part of the record. She declined to appoint Diane as Nathan's guardian or conservator. The neutral temporary conservatorship would continue only as long as Nathan's condition required it, and only within the authority already granted. Any extraordinary action involving his ownership interest would require independent review and further court approval. The judge did not call Diane evil. She did not accuse her of wanting to steal Nathan's money. She said something quieter. A sincere belief that one knows the best outcome does not create authority to manufacture the facts necessary to reach it. Diane looked down. For the first time since the accident, nobody in the room was arguing about who I was. The court had moved on to the more important question. What Diane had done. Outside, Claire explained what the ruling meant for the company. She would not cast Nathan's interest in favor of the proposed sale merely because a deadline existed. An independent valuation would be required. So would a review of alternatives. The lender might grant an extension, it might not. The company might need to cut expenses. The deal might eventually happen under different terms. There was no magical ending waiting in the hallway. 82 jobs were still attached to decisions none of us could predict. Diane passed me near the courthouse steps. She stopped. I was trying to save what his father built. I believed her. That was the difficult part. You may have been, I said. She waited for more. I had none. Intentions could explain how someone crossed a line. They could not move the line back. My phone rang before I reached Elena's car. Potomac Ridge Medical Center. Nathan was awake, not for seconds this time. From it, and he was asking for me. Nathan was sitting up when I reached his room. Not far, maybe 20 degrees, but after weeks of watching machines decide the rhythm of his day, even that looked like defiance. His speech was slow. The neurologist warned me not to tire him. So I sat beside the bed and waited. Nathan looked at me for a long time. Then he said, "Mom," one word, "enough, she's all right." That was not what he meant. He knew me well enough to know it. His eyes moved toward the chair beside me. Bad? I almost laughed. Even half recovered, Nathan still wanted the shortest version first. Yes, he closed his eyes. I did not tell him everything that day. I told him there had been a court proceeding. I told him Diane tried to get authority over his financial affairs. I told him the court refused to appoint her. Then I told him a document using my psychiatric history had been filed. His eyes opened again. He looked confused, then ashamed. That frightened me more than confusion, Nathan. His voice came rough. I sent her something. The room became very still. What? Years ago. I already knew. But knowing from an email and hearing it from your husband are different things. He struggled for breath. Trip, Richmond, you had appointment. The family reunion, he nodded. She wanted proof why we were late. I looked down at my hands. You sent her Miriam's note. Just 8. I know. His face changed, you know? Yes, he tried to lift his hand. I took it before he had to. I'm sorry, I had imagined that sentence many times during the previous week. In some versions, I forgave him immediately. In others, I told him exactly what his carelessness had cost me. The real moment was quieter. I believe you didn't mean harm. His fingers tightened faintly, but my diagnosis was mine to share. Nathan swallowed. I thought family was different. Different isn't the same as exempt. He looked away. I let him. There are apologies that ask for forgiveness. And there are apologies that finally understand why forgiveness may take time. Nathan's was becoming the second kind. 3 weeks later, he was walking short distances with a cane. 2 weeks after that, his doctors documented that he could understand and make his own decisions again. The temporary conservatorship ended. Mercer Mobility received an extension from its lender. The division sale did not happen on Diane's original timetable. Whether another deal eventually would was Nathan's decision to make. Not mine, not Diane's. That distinction mattered more than the outcome. Diane called twice during Nathan's rehabilitation. I answered once. She apologized for the document, not for believing she knew what should happen. She was not there yet. I did not ask her to be. I told her the boundaries instead. She would receive no information about my medical care. Nathan's health information would be shared according to whatever authorization he chose. Company decisions would go through formal channels. No family shortcuts, no verbal understandings that became something else later. She was quiet, then she said, "You really don't trust me." I trust what happened, that was all. A month later, Nathan and I sat at our kitchen table with Alina. This time there was no blue court folder, no hospital bracelet. No one unconscious. Nathan had decided to execute the documents we should have completed years earlier. A healthcare advance directive, financial powers drafted for the authority he actually wanted to give. Successor agents, limits, instructions. Elena went through every page. Nathan asked questions until she had nothing left to explain. Then she placed the signature page in front of him. I opened the drawer beside the table and took out the black fountain pen. Nathan looked at it and smiled. "You still have that thing? You gave it to me. I thought you'd lose it. You know me better than that." His hand was still weaker than before the accident. I held the cap while he signed, slowly, deliberately. His own name, his own decision. For weeks, that pen had helped me organize facts because facts were safer than feelings. That afternoon, it meant something else. Consent. I used to believe composure was the same thing as strength. The army rewarded composure, courtrooms rewarded it. Families sometimes exploit it. There is a kind of silence that keeps you steady. There is another kind that teaches people they can speak for you. I had confused the two for longer than I wanted to admit. What Diane did never became acceptable because she was frightened. What Nathan did never became harmless because he loved me. And what I did not say never became someone else's permission. I did not need revenge. I needed the facts returned to their proper owners. For years I had treated understanding someone's reasons as part of being fair. I still believed that. Diane had been frightened. Nathan had been careless in a way that came from familiarity, not cruelty. Knowing those things mattered, but understanding why someone crossed a line did not move the line. That was the distinction I had missed. Forgiveness and access were not the same decision. You could accept an apology without restoring every privilege that existed before it. You could love someone and still require them to knock. You could understand their fear without letting that fear become authority over your life. The black fountain pen stayed in the kitchen drawer after Nathan signed the documents. For weeks I had thought of it as the pen I used to organize evidence. Later, when I saw it, I thought of his hand moving slowly across the signature page. His name, his choice, that was the part I wanted to keep. Not Diane losing, Nathan choosing. Nathan's decisions belonged to Nathan. My history belonged to me, and from then on, anyone who wanted access to either would have to ask, not assume.